This is the Know Your Law series by Barefoot Law, a non-profit organization which uses digital innovation and technology to provide free legal information and guidance for all. For more information, visit www.barefootlaw.org.
Hello everyone, I am Anna Magembe. I'm a lawyer, and Barefoot Law has received quite a number of questions concerning succession and inheritance. I am here to answer some of them. It is possible to make a will even if you don't have any property, despite the fact that the clause on distribution of property is the heart of a will. You can make a will where you wish to be buried, who you wish your children to remain with as a guardian following your death. Yeah, you could make a will and just state some of those few issues and leave out the clause on property. If you distribute your property while you're still alive, and that means you don't have any property to give out under the will, you can as well go ahead and make a will and make provisions for where you would wish to be buried, who would wish your children to remain with, and also clearly state that you have given out all your property, and so there is no property out there that your family should look out for after your death. There are instances where someone gives away property while they're still alive. After you've given away that property and transferred ownership to another person, it could even be your child, it could be any family member, those people have a right to chase you out of the house if you're still alive. So if need be, or if they want to use that property that you gave them, that property no longer belongs to you. It belongs to another person. So they have every right over that property. If one of your family members has tricked you or, without your knowledge, obtained letters of administration without your consent, then you can apply to court for that grant of letters of administration to be revoked, and court will do the same. You can apply to court and state your right in which you're applying to court, as well as how probably you are tricked, and you give details on that and give reasons as to why you want or you're seeking that grant to be revoked by the court, and court will do that. When it comes to property, there are different classifications of property. There's tangible property and non-tangible property. When it comes to non-tangible property like shares and money in bank accounts, to be able to access that, you will have to definitely obtain a grant of letters of administration or a grant of probate. When it comes to shares, you notify the company where the deceased held shares that the deceased has passed on, and you are now the personal representative of the deceased. You are the administrator of the estate of the deceased, or you are the executor of the will of the deceased. And the company will respect that. And you will be given an opportunity to choose whether you, as the beneficiary or executor of the will or administrator, continue being a shareholder, or you want to sell those shares to another person. If it's bank accounts, then there are different bank accounts. There are bank accounts that are solely owned, then there are bank accounts that are jointly owned. When it comes to solely owned bank accounts, then you cannot inherit the bank account. You inherit the money that is held on the bank account. For you to be able to access or even get to know the balance on the account, then you're going to have to give a copy of the grant of probate or grant of letters of administration to the bank, and the bank will recognize that you are the personal representative of the deceased and will give you the money on the bank account and transfer it to the account of the estate of the deceased. If it's a jointly owned account, then the surviving person takes all that is on that account. So that's the difference with the two accounts, and that's how you can inherit non-tangible assets of the deceased. There are so many people that actually distribute and divide the property of the deceased without getting letters of administration or getting a grant of probate from court. The issue about this is that much as there are things like clothes that you can actually distribute, there are things like property that you cannot transfer ownership, bank accounts that you cannot access, and retirement benefits that you cannot access unless you have the grant of letters of administration or grant of probate from a court. I advise that you actually go ahead and get the letters of administration and grant of probate for structure and for access to anything. You just never know. There are instances where there are probably 3 administrators of an estate and land needs to be sold, or they two have agreed that land should be sold and one does not agree to it. The sad reality of this is that it brings the sale to a standstill where you're going to need the signature of the third person. So the sale cannot go on until that person agrees to that sale. The same applies to any other decision to be made by the administrators or grantees of probate in respect to the estate. And if there is contention amongst the administrators where there is reasonable cause that one has held consent to any decision or anything, then the other administrators can go to court to seek resolution on the matter. Also, if you are a spouse of a deceased person and you hold property as an administrator of an estate or executor of the will, that means that you hold property in accordance with the provisions of the law when it comes to a person who didn't leave a will, or the provisions of the will if someone left a will. This means that you hold the property as a manager and do not deal with it as you wish. Then, if you inherited that property or you were beneficiary of that property in accordance with the provisions of the law, that property belongs to you, so you can deal with it as you wish. It is part of your estate. You can sell it, you can rent it, you can do anything with it. If you have inherited property from a deceased person, for you to be able to protect that property, you have to transfer the ownership of that property from the deceased's names to the names of the administrator of the estate, and the administrator of the estate will sign the transfer documents or the ownership documents to your names as a beneficiary. And as a beneficiary, you can be able to do anything with the property after that. Any child can inherit property from the estate of the deceased. This is regardless of whether they were born in wedlock, outside wedlock, or they were adopted by the deceased. If you have a grandfather who probably passed away and had children, and you are a son or daughter to one of his children who unfortunately passed away, you are entitled to the share of the deceased child of your grandfather. That share is what you get as the children and divide it amongst yourselves. Basically, it means that you are entitled to anything that your parent owned and inherited from their parents as well. If someone died and left a will, and then after you discover that there's property that was left out of the will, what you do is process letters of administration to administer the property that was not bequeathed in the will. There are instances where a co-wife gives birth to a child, and the question is, can that child be entitled to the house where the first wife is staying? Well, if that house was passed on as a home to all the children, all the wives, and all dependents of the deceased, then that child is entitled to stay in that house and call that house home. If that house is not considered or cannot be considered to be the home that was passed on to all the other children, and it was property that was not jointly contributed to by the deceased and the first wife, then it's considered to be property of the first wife and forms part of the estate of the first wife. And that means that it is her personal property and no child except her children is entitled to a share in it. If someone has passed away, who is eligible to be an administrator of an estate and an executor of an estate? The person should, one, be aged 21 years and above. Should be definitely a person with the mental capacity to actually do the job, that is, they are sober-minded, and definitely possess the values of honesty, integrity, and can easily be trusted with responsibility. There are people who want to give away their property while they are still living. Well, that is possible. You can give away your property while you are still living and ensure that you give this property away freely. The person could pay for that property, or you could just give out of free will and gratitude or any other reason to that person. Ensure that you transfer ownership from you to that person. This means that this property will not be considered as part of your estate when you pass away and cannot be inherited when you pass away.
Hello, welcome to the Know Your Law series, where Barefoot Law answers frequently asked questions on the law. Do you have employment issues? Questions about family law, criminal law, land transactions? The answers are right here on the Know Your Law series.